Hello, welcome to This Family Does Everything. My name is Alexandria. This is a video of all Darrell Brooks versus Judge Dorow. So I did it in parts, so this is part one. So let's sit back, watch, and analyze the Darrell Brooks trial.
Oaths of office, my name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I am not.
I realize it may very well be related to your claim to be a sovereign citizen and disputing the
claim to be sovereign. That's correct.
Jurisdiction of this court, but these are not questions this court is obligated to answer.
I would like to correct the record and say that I am sovereign.
All right, you believe you're sovereign. The record is corrected. So, Mr. Brooks, we're getting really close for you crossing the line.
Really close to crossing the
line.
Being
removed from the courtroom for continued interruptions.
I want you here. To that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning. It is only, it's 8:57. I want you to be here. Certainly my preference is for you to be here to participate fully, but you do not have the right to disrupt the proper administration. I demand dignity, order, and decorum. You have been provided with the copy of SCR Chapter 62 that lists the responsibilities that myself, the attorneys in this courtroom, the litigants, it even applies, as you can see if you read it, applies to witnesses, jurors, those in attendance. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in front of me.
I'm going to continue with a finding right now that you have flagrantly disregarded elementary standards of proper conduct. That conduct will not be tolerated. You stating things even in a mild manner tone of voice doesn't change the fact that we've had a dozen or more interruptions by you and by you alone. When you don't like the answer I give, even if that's a non-response, you continue to ask the same question over and over. You repeat yourself. You show absolutely no respect for the court, for these proceedings. You have demonstrated in the short, not even 30 minutes that we've been on the record, that you will continue to disrupt. I am going to have the jurors brought in. Again, it is my sincere hope that you follow these simple and basic rules, but the next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law. I don't give my consent.
We have the jurors here?
And I will not agree to anything.
Not yet, okay.
So again, with that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of Your Honor numerous times at this point, can that title name please direct the prosecutor to answer whether there are any more charges? Can the title name please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks,
in her possession?
No one's going to be answering these questions, okay? I'm not requiring the state to do that. I'm advising you to stop asking those questions. It will be considered an he's interrupted. Take him to the next courtroom. I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
Or agree to a estoppel, and I will move the court again.
Currently, you are not muted. All right, Mr. Brooks. All right, you can mute him. All right, Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning. I understand that you object. Your objection is noted. Your lack of consent is noted. As I indicated earlier, I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions that I told him I would not answer. And even though I made a decision not to answer questions, he keeps asking those. From my perspective, they are questions that any sovereign or sovereign citizen tends to ask regarding my name, my oath, jurisdiction, things of that nature. This court, of course, has authority from the Constitution of the state of Wisconsin, the statutes. I've been duly elected twice now by the citizens of Waukesha County to preside over criminal and other cases in the courts of Waukesha County. I fully am aware that Mr. Brooks, as a sovereign, disputes the validity of that, but from my perspective, they are not issues that need to be debated. He raises these issues really just by simple statements. He has never filed an appropriate motion. Motions are governed by state law. Written motions require that the specific relief be requested, that the motion be based on law and fact. I've never gotten anything even close to that from Mr. Brooks. Even if I were to accept an oral motion, which can be proper at times, he has failed to follow the simplest of procedural requirements. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction, he's yelling what, I can't hear him, but it appears that he is yelling. I muted because of his interruptions of the court, and I understand he objects. His objection is again once is noted. And because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. I have the ability to mute, to unmute. I can see him. He can see the 4 cameras in this courtroom right now. That would be me. It would be the table where I would like him to be seated. That is empty, the prosecution table, and then the witness stand. I am cognizant that the one limitation is the cameras do not pick up the jurors when they sit. There may be, depending on the angle on the witness stand, a few jurors that would get captured, but of course he cannot see those. He's able to hear them, of course. I will instruct the bailiffs over there to give him a pad of paper if he doesn't have one already. I know he had some documents and some things in front of him. At one point, I saw him sort of do a sweeping motion, and things seemed to go flying. I'll get some verification of that from the bailiffs who are over there through the bailiff that is in my courtroom. But he will at least be given a notepad, a writing utensil. He is advised that should he want to raise a strike for cause of any juror, my procedure is to address that at the end. Certainly if something comes up before that and he wishes to do that under the law, he can simply write on the pad of paper he has cause, hold it up, and I'll make a determination if I should excuse the jury and then take up that decision. I'm probably not going to do that with frequency. He would need to further not only do that, but write on a piece of paper the juror number, the basis for that request before I would require the jurors to be excused to take it up. But that's the procedure that this court will follow. I've been advised that Mr. Brooks did throw some items on the floor, but he does have his paperwork and a pen.
Your Honor.
Go ahead.
I just want to make sure that we put on the record that it has been verified that Mr. Brooks can hear this court.
We'll do that, yeah.
Also that I believe I had heard that the juror questionnaires for the next set of jurors coming in have been provided to Mr. Brooks?
Thank you for that reminder. He has been provided with 2 additional binders. He probably doesn't even have the first one anymore because the first binder only went to juror number 41. He does? He still has it? Okay, so he has that binder. He has 2 additional binders. Were we able to verify? We were able to verify the audio is working. The video is working, just like we can see him. He can see us. For those of you who are in the courtroom, what he would be seeing on the monitors would be that 4 square as well. Because it is through the Zoom, he would have his picture as well. So he would see the double image, if you will. I should also make a record that there are a number of individuals on my Zoom as well.
Your Honor, the only other thing, and I think the court somewhat made a record by your findings, but I know that the defendant made 2 motions to dismiss for judicial misconduct. Again, I'd ask the court to summarily deny those motions based upon lack of merit, and he didn't provide any support for either motion.
I believe he did raise a motion to dismiss based on judicial misconduct. I think he also threw in there another request to stay the proceedings or file an interlocutory appeal. While that's really not something I would need to address because nothing's been filed as it relates to a request for an appeal, I will deny that summarily. There's been no basis in law or fact provided. I'll also deny the motion to dismiss based on judicial conduct, based upon there being no showing in law or fact. All right, anything else then before the jurors are brought in?
No, Your Honor, thank you.
I will, just like I did yesterday, advise the jurors that Mr. Brooks is appearing from a remote location, and that should not influence their verdict in any way. It appears to me that Mr. Brooks continues to stand, make hand gestures, and talk. I will, again, just advise him, should he desire to raise any issues with the court, he is advised to write that down on paper. The bailiffs are instructed to promptly provide that either to the court staff that's in there or another bailiff, and that will be provided to me forthwith so that I can raise any issues of merit. All right, with that then, we will begin the jury selection process, and so we can go ahead and bring them in.
They don't mistake. I know, but I couldn't contact her to say it's going because I forgot my phone upstairs.
So the judge would like you to cross off any people that are already named in number 8.
Oh, yeah.
Okay, then I think.
What are we doing?
All right, we are back on the record. Mr. Brooks, I was able to inquire. I've been told it would take maybe 15 minutes, but I'd like you to go to your cell to get whatever that list is that you have so that I can adequately advise the jury, potential jurors, about any witnesses who may be called in this case. I don't designate when I say if it's the state or the defendant, but you told me you have that, so I'm going to give you that opportunity. In the meantime, I'm going to print off the state's witness list.
I don't need it.
And give them to the state so that you can cross out any individuals who are already listed in question 89.
We have that already, and we just started doing that.
All right. And then what I plan on doing is once I finish with all of the questions and the follow-up of this group, I will bring, and then we'll discuss if there are any additional strikes for cause, okay? Once I get through that, I'm going to bring in all of the jurors. We'll just figure it out from there, but I'm not closing the courtroom by any stretch of the imagination, but I need to, it's a long witness list. I need to make sure none of these jurors know any of these individuals. either personally or by reputation, work with any of them. But we should be able to do that, still maintain some room for victims, some room for the press, and we'll go from there.
And Your Honor, just one other quick thing. I know that you asked the defendant if he had any questions that he wanted you to ask. I would just, the issue that he's brought up with being deaf in one ear, I'd also ask if he has any questions of yesterday's panel that maybe he's unclear or didn't hear anything, although he didn't notify anyone he was having trouble hearing. He was answering questions in the other room without the headphones on. Actually, he was given the headphones. It took him a minute before he even thought to put them on. But just to see also if he has any questions, obviously he's got to follow the Supreme Court rules, but if he wants to ask the jurors any questions, either from yesterday's panel or today's panel, any concerns that he may have about any of them.
I would agree that that's a good procedure to employ, Mr. Brooks, so you'll be given that opportunity. I would note he does not have the headset on here. I can make a further record that previously especially when I went through the waiver of right to an attorney, I realized that was in this courtroom, but he at times would answer, I hear you, or I heard you. But Mr. Brooks, you're advised that if there are any follow-up questions on anything you didn't understand or you believe you didn't hear, we will have all of the jurors at one point that are remaining from yesterday and today brought in the courtroom. All of them have numbers, and you'll be able to do follow-up that is appropriate. Now, you also mentioned previously when I referenced going back to your cell to get the list. I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that. The question was, where was the list at?
That's true. So you said the list was in your cell. I'm advising you that I'll give you the opportunity to go.
I don't want to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, your one option would be to verbally tell the court any additional names to what you've already provided. Write those down for the court so that either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
The list that you have in your cell?
How am I supposed to do that without the list?
I'm telling you, I'm giving you the opportunity to go get that.
I'm not going to go do that.
Mr. Brooks, I'm not going to play games with you.
And
I'm giving you an opportunity.
And I told you that I'm not
either go to
going
your
to do
cell
that.
and
You
get
said
the
I have the
list or not.
opportunity to do that.
All
You
right.
said I have the opportunity.
I'm not going to
do
demand that you do it, but you have to understand, sir, that if you choose not to do that.
I don't understand. I don't understand.
All right,
I've
Mr.
made
Brooks.
that clear. I don't know how many
You claim to not
times for the
understand,
record.
and that's been made very clear,
I don't
sir.
understand. You're not going to get me to consent to something that I don't consent to or agree to. I do
No.
not
All right.
understand. Just
Mr.
like I
Brooks,
don't
we're gonna
understand the
take a
nature and
recess
cause
so
of this.
that the court can get this
exactly
information
like I've
from
been
the
telling you
state.
from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned, once again, if you continue with that, you will be removed from the courtroom.
Remove me. Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even came over here.
Sir, are you requesting to
I
go?
told you that before I even came over here.
Mr. Brooks, are you
That
requesting?
It was pointless of me to come over here. You can smile all you want and think
Sir,
it's funny. I don't take this as a
preference-
joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet
Right.
to verify anything
You
by
can take
sworn
him back to
affidavit.
the other room.
You
He's
haven't
been
even honored-
disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies and
haven't even
gentlemen. We'll
honored-
have to,
you haven't even
clear
done
the
that.
courtroom.
I don't agree to a stop when I move this court for a motion to dismiss.
The record should reflect
The record should reflect that my rights are being trampled on. The record should reflect that I don't agree to a estoppel. This is ridiculous, man. As soon as I raise the issue, I'm being disruptive. I'm intentionally trying to be disruptive. I'm intentionally doing this. I'm intentionally doing that. So I should have just stayed over here, which ain't even legal to do anyway. Can't be present and not present when it should be a motion. This is ridiculous, man. This is ridiculous.
Okay.
You're forcing somebody to agree to something that they ain't agree to. Y'all come up with anything y'all can. Anything y'all can, huh? Why I need that in here? You could have left that over there. I'm going back over there anyway.
Just in case.
If I'm right here in front of the face, I ain't gonna have no problem hearing. That's why these could have. I'm gonna have to go back over there. Y'all know that.
We'll bring it with us.
I'm just saying, man, this is ridiculous, man. This is ridiculous.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr.
I do not
Brooks,
identify by
it
the name
wasn't
that
the
you called me
proper
by.
time
That's
to
all.
do that. That's now the third interruption. So,
With all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is
I
my
have
right
a number
to-
of documents
it is
that I
my
need
right
to discuss
it
this
is
morning.
my right to,
Mr. Brooks, you do not have a right to interrupt the court.
No, it
I will
was-
remind
that was
you
not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I
did not
checked, I
recognize
verified,
that.
it
I
is.
accept it in return for
Mr.
value,
Brooks, that's
Your
yet
Honor.
another interruption. Let me get through this, please.
I just want, for the
You will
record,
have an opportunity when I give you an
I want
opportunity. No
to
one
state
else
it.
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am
object-
well
I
aware,
object
that's another
respectfully, Your Honor.
interruption. I'm
I
well aware,
object
stop
respectfully, which I have the
talking.
right to do.
I'm well aware,
And
Mr. Brooks,
I
that you
have not
object to the
intended to
name that
cause any,
has
disruption.
identified on the information and all documents in
wanted
this
noted
case.
for the
Your
record that I
objection
did
is
not
noted. It
identify
does
by
not
that
need to be
name.
repeated. I will make a record right now. The
May I
court
have the
notes
opportunity to
a
preserve my
continuing
rights, Your
objection
Honor?
by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously
I never
related
objected
to
to
that.
being
Those
here. I just
documents
state-
are
I tried
of
to
record.
state
There's
that
another
for the record,
document
Your
that's
Honor.
filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio
I don't
means to
consent
participate.
being removed from the courtroom, Your Honor.
That's another
And
interruption.
you haven't shown me any lawful case law that I can be removed from the
Mr.
court
Brooks?
proceedings in a trial and forced under coercion and duress to appear in the trial that I am needed, that I've tried to express that I have the right to
Mr.
be
Brooks, there's a
present for.
proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility.
You haven't
You
given me the
interrupt,
chance to
you don't wait for
state my
anyone
name.
to finish, and it will result with you being removed from the courtroom.
I
So
respectfully
you are
object to that,
once
Your
again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around
feet are
each
shackled.
one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr.
Who
Brooks,
doesn't know that?
I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street
I
clothes?
do not consent or agree to anything that you just stated, Your Honor.
All right, he did not provide an answer to a very direct question. Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back, Mr. Brooks, that's yet another interruption. I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about whether you would go back to the jail. That's another interruption. So based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily and intelligently. No one has forced him to come to jail in those clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
You just weren't speaking,
all right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the other courtroom.
I don't consent to that.
I have had
under
a
duress
dozen or
by
more
having
interruptions.
I
We'll
have
be
shock-
off the record while we
shocks
do
on my
that.
ankle.
Thank you,
I
everyone.
don't agree to a stop. I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not. I have a right to be present for trial.
Yes. You're able to see the screen, is that right? Okay. Yes. I'll publish that as well. All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera, since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present, I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m. At all times throughout the court's statements thus far, since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no. At a point in time where it's clear he's disagreeing with something that I've said, I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to delay, to create chaos. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear if appropriate. All right, I received a note, we need to reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate, make a record as to why and whether that impacted anything that was happening in the other room. But at this point, well, I'm not going to get off the bench. We're going to take a short recess for that resetting to take place.
I would request an opportunity to be heard then, Your Honor, when we go back on the record, please.
Absolutely. I wanted to make sure that the record is very clear. I will note a continuing objection to the issues he raises regarding his name and other things. There are filings that substantiate that. It will be my position it's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern, and I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case, and you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated, and the court has seen this since August 25th or so, as the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that with the court because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things, frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it with to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. Where is the microphone? It looks like it's in front of the monitor. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday? Go ahead, answer please. All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, the volume is not being appropriate at the moment. Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer, so I just wanna make that record. I'm gonna go take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there. I believe that issue has now been resolved. When I needed to take the break for the audio issue, I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small cut to a finger as a result of when he was removed from this courtroom and taken to the other courtroom. I was further advised that there are no signs of blood, and that when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done. And I also want to make a record that Mr. Brooks has put his shirt back on. He continues to sit with his back to the camera. Mr. Brooks, I want you to be advised that I believe it's important that you face the camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment you are not. But at this point, given your conduct from before, I'm going to require, after we take the next break, that the Sheriff's Department put you in the chair face forward and with shackles on your ankle, as you are in custody, and that is appropriate. Now, I want to turn back to the issue with the jury instructions. Mr. Brooks, you indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around. Mr. Brooks, I'll ask you once again, what is the legal basis for your objection to the jury instructions? I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't allowed to make, I can't even hear what she's saying all the way, man. It's too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on.
Mr. Brooks? You just put it down. I don't know.
I'm able to hear. He said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those. Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document. based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
All right, thank you. Then we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opper, I have read through the motion. Is there anything you want to add to what you have put in your filing?
Only one other observation, Your Honor, that since I filed that, the events of the last couple days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify, and so not having their faces displayed, I think, would help ease some of that tension for those individuals.
Mr. Brooks, my first question to you is, do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer. I'll unmute and provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed, and you were provided a copy of that yesterday. We took a recess yesterday so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify?
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue.
I take your...
It's a public trial. It's a public trial. Anybody can essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name, that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty easy for them to be found and to be seen. So, I mean, that's just the age we're in anyway, as far as with social media and Google and all these different things. We got all this technology basically at our fingertips. So I don't understand how it needs to be changed at this point when it was already ruled that this is a public trial. There's going to be a lot of things that are going to be shown. Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on a record, Let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 U.S. 532, but I would note it's from 1965. In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast. Not just locally, but nationally, and frankly, anywhere in the world, anyone with a computer would want to watch. I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by a court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done, up to this point, everything that I could to preserve their privacy. I don't, frankly, want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I'm aware of Marcy's law. Certainly aware of the provisions that the state cites, but the fact remains the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. All of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process. In the jury instruction, the names of all the victims will be read. The state agreed that it was time to put that information in a public document and on the record because the time for trial has come. The cameras in the courtroom not only facilitate the viewing of a public trial where anyone could walk in to this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this case. This court could not have all the victims and the public and the media who wanted to be here present. Frankly, I think it's because of how this court has allowed the proceedings to be live streamed that we don't have even a full courtroom here today. There is no doubt this case has received great public interest, but this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course, if and when a juvenile witness testifies, may only be captured from the shoulders down. Their faces are not to be broadcast. Again, I am not unmindful of the impact, but in my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media. It's very easily to identify these individuals and search for them in other ways. I'd also add that there have been a number of news reports, media accounts, newspaper articles about victims, naming them. I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And I want to keep this trial going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had for this morning, that we've covered all of the outstanding issues.
Your Honor, if I may, I don't want to interrupt, but I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted, it has been filed, and that your objection is noted. The court need not take any specific action as it relates to it. I further indicated that, again, no relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork, I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right, I'll note
so
that for the record, sir, but it was not in your filing.
So that's a judicial determination, Your Honor?
I believe I had one other thing. Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the Sheriff's Department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks?
The reason
Mr. Brooks?
I would just want to...
Hold on, I'm going to mute you for a second unless you stop and listen to me.
I just heard what you said, but I just...
I'm not asking for a response, sir. Mr. Brooks?
It's not
Okay,
accurate,
you're
Your Honor.
interrupting. Hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me, and then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
No, I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time. But then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm going to mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
All right, I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors brought in.
And I think Mr. Brooks needs his objection signed.
We'll make sure he has it.
Thank you.
Let me actually go back on the record for a second. Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions. I don't know if that will take us to the lunch hour or not. The state should be potentially prepared to go through its opening. Mr. Brooks, if we do get to that point where the state is giving its opening and you have an objection, you need to write down the objection in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to. in addition to holding up your sign. That's the procedure that we will follow. The seventh count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger Wisconsin statutes. The eighth count of the information in sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The ninth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life, sub 1 sub B of the Wisconsin statutes. The 10th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1 and 939.63 sub 1 sub B of the Wisconsin, did recklessly endanger the safety of Mackenzie Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3. I do want to make a further record that he still remains in his jail attire. Prior to the break, I did advise the captain and to let Mr. Brooks know that he certainly could take the opportunity during the lunch hour to put on street clothes. So it's his choice. He is here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
Just for the record, Your Honor, they never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Thank you. I appreciate that clarification. Nonetheless, I provided you with that opportunity, and here you are. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. All right, I'd like to bring the jury out, Mr. Brooks. I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to strictly jury instructions or the filings that I filed on the 3rd?
I'm not addressing those at this point,
I
sir.
was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
Right. I'm not addressing any of those filings. I previously addressed those. It may not be to your satisfaction, but,
Remember what you said, to be honest about those.
and I'm not going to repeat myself. So the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record. And they will be available for you at a later point in time should you be convicted and on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
Reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings. So you will have an opportunity after the state presents their case in chief and they rest to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
I don't understand, though, Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions, and then come back with opening statements. And you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
Well, I'm trying to seek to understand how the testimony evidence that was given could be considered
Mr. Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction?
No, there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr.
bring
Brooks,
up
I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor.
Your objection to my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face, the penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored and granted.
That is inaccurate
And
because
Mr. Brooks, don't interrupt me. Okay, now that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not
please,
my intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm
All
not
right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you.
So what are
The
you
fact
gonna
that
say?
you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So
I
at this point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek
interrupting
to
me,
understand.
sir.
I was
If
in the
you
middle
have
of
an
saying
objection, write it down.
something. I thought that applied to me being.
It's
from
applying right
another-
now since you keep interrupting me while I'm talking.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All
a
right,
reason
I'm
why?
not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's inaccurate,
All right,
Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line-by-line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be.
It doesn't
But
have
we are
anything-
continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
Your
Madam
Honor,
Clerk, have the jurors brought
Your
in,
Honor,
please.
what you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings, and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the right the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
do you
It is not to-
understand when I tell you not to interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to
Mr.
ask
Brooks?
questions, Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr.
that
Brooks,
you have
the
not
jury
shown-
is in the courtroom.
I understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It is my right.
Mr.
I'm
Brooks,
merely
you
exercising
can
my
stand.
right.
You need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor. It must be some clarification.
Mr. Brooks, I want you here.
I want to
Stop interrupting me.
be here. You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, cannot.
Ladies and gentlemen of
You
the
can-
jury,
you can
I'm going
move
to
me to the other
continue
thing.
with the jury instructions. I'm on count 38. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree weapon. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 54, you should find the defendant guilty. Information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle which must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved, before we have the parties or before I give them the opportunity to make opening statements, I am going to excuse the jurors to address a few legal matters, give you an opportunity as well for a short comfort break. We'll let you know when we bring you back in.
allowed to say something on the record really quick?
Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognized her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is later.
Do we know the number?
Do you know the number of the jurors, sir? They have numbers.
I just know that I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black shirt
They're all
on.
black chairs, sir. So
The last
chair
black
closest-
chair closest to the television.
Thank you, sir, because there are two sides, right? So there's the last chair on both sides. So I wanted to make clear. You're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
Front row.
Is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, "I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit, filed 10/3/22, which today is deadline to respond." Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings.
That's my decision, sir. Next
Are you
topic.
making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding of fact.
Your request is denied. The next,
May Your Honor explain why it
Mr.
is
Brooks,
denied.
I'm gonna go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making the error, Your Honor.
Mr.
You wanna
Brooks,
explain
I'm
to
not
me
going to
why?
have a debate with you right now. We are
not-
continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52
I still would
p.m.
like a judicial, are you making
says,
a judicial
are you making a
determination?
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law there is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not
And
disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will that be honored by your honor? That's a valid question.
Mr.
Because
Brooks,
that's a constitutional
I have
right.
given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even
So-
get these admitted into evidence.
That's, Mr. Brooks, I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand. But
So,
I was
but that
following-
doesn't mean we're going to have a
I was
discussion
following- no,
or a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to do
following
that.
the rules that you said.
So the bottom
by
line is, I
writing
don't
and
feel,
sending it.
Mr. Brooks, stop talking. I do
No,
not
I was
feel,
right. I was following the rules when you said that I had to make all
and you
objections
did, and I'm going through
in
them,
writing.
so give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All I'm
Brooks,
saying is,
I'm going to address the next one,
what
so
you-
please pay
What you
attention.
were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's
Brooks,
all I'm really-
again, you have the right to present a defense, but that right is not unfettered.
But that's
That
the Sixth
right,
Amendment. I'm
Mr.
talking
Brooks,
about the First
you
Amendment.
are interrupting me. Stop.
Because you're talking about
No, because you're
talking about an
purposely
amendment that I'm
doing
not
this,
referring
so
to,
I
Your Honor.
can't get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment.
Mr.
I'm referring
Brooks.
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial. What
Mr.
you're
Brooks,
doing
you
is
also
not
have
fair
an
and impartial.
obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor, I did
That's
not-
the playing field that you willingly entered into and made a deliberate
I did not.
decision to waive your right to an attorney
I
and
cons-
to appear
I
in this
consented-
case as
I
your own
consented
attorney.
to represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on
But-
there, I
but
made
you-
very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right
You also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage in
We did
any
not.
type of
did
that
not
kind of
enter into
dialogue.
any
Because
contract.
that's what you're claiming through some
No,
of
I'm
these
not.
filings,
I'm
and
not
you've
claiming
said that
I
previously.
am not claiming that, Your Honor.
So,
In any way,
Mr.
shape, or
Brooks,
form, I do
I'm
not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. It's, you please, I'm asking you to follow the rules of civility. Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's
So,
being asserted
here's
on my
what's
end.
happening, sir.
All
I'm
I'm-
telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir. And then I'll bring you back when the jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing this court with
inaccurate, Your
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor honor my First Amendment right?
I'm
Or
not
are you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination,
So
sir.
you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the First.
present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
your
are, Your
rights,
Honor. You're citing the Sixth Amendment, which I am not
Mr. Brooks.
questioning.
Your
I'm-
First Amendment, in some respects, is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So it
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of a
I'm-
jury.
Your
And it
Honor.
doesn't mean you get to put forth any kind of evidence that you want
Your
in front
Honor,
of a
am
jury.
I
What
being-
it means, sir,
am
is
I being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out your
you're being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeited his right to be
I have
present
not
as I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your
everything
Honor, I do
set
not
up.
agree to a
The record to reflect I'm stepping off. The record should reflect that Mr. Brooks is now appearing from the other courtroom. Prior to the court taking the short break, the court was attempting to address the filings from Mr. Brooks that he made pursuant to my request to write down if he had an objection. I have 5 different what I will refer to as filings, one of which he provided to Deputy Wittig at 12:05, so that was right around the time we broke for lunch. A second one, 1:52 p.m., today's date, October 6th, and then there's another 1:58 p.m., October 6th, 2:03 p.m., October 6th, and then looks like the time is 14:28, so 2:28. The other one was received. Mr. Brooks, I'm going to make a record first as to why you've been removed, and then I will hopefully get to the filings. I need you to not interrupt me at the moment. You are unmuted. But after the court completed the preliminary jury instructions and the reading that is to the jurors, I excused the jurors so that they could take a break, but also because I knew there were a number of what I will loosely refer to as objections that were raised by Mr. Brooks. So I wanted to take an opportunity to address those first before moving on to opening statements. As I attempted to address those with Mr. Brooks, there was, from my observation and opinion, and I'll make a finding that it was pretty much a consistent talking over me by Mr. Brooks. I wasn't able to really go through any of these filings with any specificity. I attempted to go through the first one, which I did. I mean, I did tell him I wasn't going to address that. And then we were talking about his second one when really it kind of devolved from there. The record is very clear that Mr. Brooks has been advised on multiple occasions of my expectation regarding courtesy and decorum in this courtroom. I've referred to at many times that there's a very simple rule of civility I expect him to follow at a minimum, and that is to not interrupt. It shows a complete and utter lack of respect for the court process, the court proceedings. It interrupts the court as the court is attempting to make a record of what is happening and decisions that I am making. And after repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings. The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple, it is disruptive. It disrupts my thought process, it disrupts the proceedings. I was so pleased, Mr. Brooks, when you were able to follow the simple rules when the jury was here and I was going through the jury instructions. I know you had some objections, you wrote them all down, you followed that procedure. I told you I would take those up after I got through the jury instructions. I was attempting to do that, but then you started in with your antics, with your interruptions. It doesn't matter to this court if you're mild-mannered, if your tone of voice is a normal tone of voice, meaning it doesn't matter to me that you're not raising your voice, you're not making any threats or anything like that. That certainly would take things to the next level, in my opinion, but it's not necessary for this court to make a finding that your behavior is disruptive. And this obviously comes on the heels of your conduct this morning, where you spent the vast majority of the morning in the other courtroom based upon your conduct. And I'll ask the state if the state sees any of that differently.
No, Your Honor, and I would cite the court's United States versus Benabe, B-E-N-A-B-E, at 654 Fed 3rd 753. It's a Seventh Circuit case from 2011. Specifically, there's very instructive language on page 767. This case involved a defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever. The quote is, the proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial, that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
And I believe Benabe and the language that you cited is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being ruled upon. Then the second filing, we heard him discuss at length, so I'll just have the state respond to that, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and they can be fettered under appropriate situations, and you've made an excellent record as to why that is appropriate in this case.
Mr. Brooks is raising his objection sign. Since he was given an opportunity to address this previously, I'm not going to give him further opportunity and simply indicate that he will be allowed at appropriate times under the rules of evidence, under the to present his defense. It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial. In addition, any of his specific objections should be brought by motion. Even if that's an oral motion, it should be based in law and fact and request specific relief. His filings make claims that have no underpinning in law or fact. It's really conclusory. This court is under no obligation to address, conclusory statements by him that are not properly made, both in form and in substance. This record's replete with references and instances of Mr. Brooks just simply spouting various amendments or theories without those fully being established in the record. And again, no constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered. That is especially true in a court of law where there are rules of evidence, rules of procedure, where we have the standards of courtesy and decorum. He can present his defense. He has a right to present a defense, but his rights to do that must comport with the law, and that law is what I've already pointed out. So I'm not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court. So I've answered this. We'll move on to the next one. And he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. If I mispronounce his first name at times, my apologies. I know I said it, his name repeatedly throughout those jury instructions. I know when I first had hearings on this case, even his own attorneys referred to him as Darrell. And it was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's right. Or words to that effect. I may not have the exact quote, and I'm not quoting him, but he confirmed for me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to address it further. His last document, which says a plea is to argue facts. I don't intend to do that, and I never agreed to or consented to a, quote, not guilty, quote, plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. It is true in this particular case that plea was entered on his behalf, but the fact also remains that in order for that plea to be changed to something else, meaning a guilty plea or a no contest plea, the defendant would need to go through the plea questionnaire waiver of rights form and have to knowingly, freely, voluntarily, and intelligently waive all of the rights that go along with that. In other words, this court is simply constrained by the law to proceed as if not guilty pleas were entered on his behalf. So I've addressed that. I don't need any further argument from the parties. I will note Mr. Brooks continues to have the objection sign raised. The other thing I want to make a record of, we did have the civilian jury bailiffs check with the juror that was identified by Mr. Brooks, and that juror confirmed she has not attended any proceedings. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules when the jury is present. The jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to
You're
not
saying
do that, then you run the risk of once again forfeiting your right to be present.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive. And I don't understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today, nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me. Where's the give and take? It should be fair. I'm not asking for legal advice. I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings.
I am not obligated to answer questions.
You made
when
those
you ask me
filings.
questions, I'm going to mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law. I am obligated to address motions to address that are based in law and fact. I'm obligated to to address objections, for example, whether it be to testimony or evidence or questions posed to witnesses. But I am not obligated, sir, to provide you with an explanation of the law of the procedure. And with that, since I gave him 2 opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding. I will find that his non-response, that he has not answered directly, which to me says he's not willing to follow the rules of decorum and courtesy and civility, and without such a pledge, he will remain in that courtroom. He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask. And I just wanted to make a record of that. All right, then we will have the jurors brought in, and then the state can then proceed with its opening statement. Mr. Brooks, my first question to you is, will you be making an opening statement at this point or deferring until your case, meaning the defense portion of the case?
I will be deferring at this time, Your Honor. I need a little more adequate time to make sure I go over the points that I need to make.
All right, then the court will honor that request, advise the jury he's deferring his opening statement until a later point in the proceedings.
I am going to just take a short break so I can talk some logistics with the parties to determine whether it makes sense to start with a witness tonight yet. It's 4 o'clock, a little bit after, or wait until tomorrow. So either way, you'll come back because you'll either hear testimony or I'll read an instruction for you. But at this point, the jury may be excused.
I would prefer to. I'm still kind of taken aback by not being able to know exactly how many witnesses are expected to testify, and not being able to turn in my own witness list.
Well, Mr. Brooks, you've been given copies of the witness list. The state's offered you a flash drive with all of the exhibits to streamline what will be presented at trial versus what is in discovery, so you've had ample opportunity to review those. I'm happy to bring you back. I need you to pledge to me that you will follow the rules of procedure and evidence, that you will only interrupt if you have an objection.
That objection needs to be founded in law. And then you need to pledge to me that you will honor whatever decision I make so that the testimony of these individuals can proceed within the time frame that the prosecution has indicated it will take. You, of course, will have an opportunity to cross-examine them. Are you willing to follow the rules of courtesy and decorum and the rules of procedure and evidence?
From what you explained yesterday, the objections you said have to be like, I think you said like 3 words. Is the way to actually object. So I don't recall you.
I can give you up to a sentence.
What I am trying to avoid, sir, are what are called speaking objections. The idea behind that is that you give me just a little bit of information so that I can either make a determination or, if appropriate, send the jury back out so that I can then hear arguments from the parties. Some objections really are 1 word, hearsay, maybe 3 words, calls for speculation, things of that nature. So if you're willing to abide by that procedure, then you can come back to this courtroom.
I can't really definitively give an answer right now to that.
So you're not willing to follow the rules of courtesy and decorum and procedure and evidence?
That's not what I said.
That's why I'm asking the clarification
question, sir.
I was clear in what I said. I don't think I can make that determination right now.
Let me ask it this way, sir. You may reclaim your right to be present if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Are you able to do that, sir?
I thought I have.
Sir, it's I think, a fairly simple question. I'm asking you if you are willing to conduct yourself appropriately. I'll shorten it to that. Are you willing to conduct yourself appropriately, sir?
I have to the best of my ability.
Sir, please answer my question directly. Are you willing to conduct yourself appropriately?
I have conducted myself appropriately.
I'm not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the testimony of two witnesses, to conduct yourself appropriately.
I have.
That's not my question. That's not the answer I'm looking for. I'm not asking if you have. I'm asking if you're willing going forward to conduct yourself appropriately during the questioning of these two witnesses. Yes or no?
I'm going to end up getting put back over here eventually if I come over there.
Mr. Brooks, I'm further advising you, I'm looking for a direct answer of yes or no, and that your failure to give me a yes or no answer will be considered by this court to be non-responsive. So let me ask you the question one more time. Are you willing to conduct yourself appropriately during the questioning of these two witnesses?
To be 100% honest, I cannot answer that.
All right, then based on that answer, which is non-responsive to the question that I asked, he has not given me a pledge or indication of a willingness to conduct himself appropriately going forward, and based on that, he'll remain where he is. You will remain unmuted, and so if you have an objection, you can lodge that objection within accordance or according to the rules of evidence, sir. All right, with that, let's have the jurors brought back in, and we'll start with the taking of testimony.
One quick second to put this up, then you're on.
Go ahead.
Thank you. I don't think it'll take long if you want to call for him. I did the call.
Let's
Non-responsive.
You did not answer yes or no. Do you think with where that chair is, the witness will
I would ask the witnesses to have to stand where I am so that everybody can see.
Oh, that would be a good idea.
Okay.
No, you're not muted yet. Mr. Brooks, if you're asking me to make a judicial determination, I've already rendered a decision about where you're going to be.
Because I didn't answer your question the way you wanted to.
All right, I'm going to mute you, sir. Now we're moving on to that part of the procedure, since you are you're not following the protocol that I've set in place, that you are back to one of these sovereign tactics about, have I made a judicial determination? The record speaks for itself, sir. I'm not going to make a further record on that, nor will I answer the question about, am I making a judicial determination? I've made a decision, and that decision is you will remain in the other courtroom. Once the jury is brought back in, I will unmute so that you can lodge objections, but if you interrupt without making an objection and just start talking about a judicial determination, then I'm going to mute you once again, and the procedure for objecting will require that you raise your sign, write it out, and provide it to the bailiff, who will provide it to the court so that I can rule on it. If that slows things down, then so be it. But that's the procedure that I'm going to follow.
Really quick on the record, if I may.
We're going to call the next witness. Do you have a? We have the jury in the courtroom. Do you have a question, sir?
I will have a oral tennis motion I would like to be put on the record.
If you have a motion, you'll have to wait until after the next witness is called. Write it down, submit it on paper, and I'll review whether it's appropriate for this court to address. All right, the state may call the next witness.
The state calls Corey Runkle.
All right. Good afternoon, Ms. Runkle. If you would please make your way to the witness stand.
So, Ms. Runkle, we're going to play a few moments from this video. I want you to watch and see if it's the same video that you've reviewed previously. Okay, so we're just going to play about 10 seconds here.
I could just tell that's her walking up.
Okay, let's pause there. So you viewed this video. Is it an accurate depiction of how the events unfolded in front of the school you're talking about?
Yeah.
I'd move Exhibit 3 into evidence and ask to publish.
Any objection, Mr. Brooks?
Yeah, my objection would be, you've only played 5 seconds of the video, whereas the other 5, you just said 10 seconds that you would play. I'm curious to see the rest of the video.
Your objection is noted. It's overruled. This is for foundation to establish it's what the witness is going to testify about. She's testified. It's a fair and accurate depiction of what the events that unfolded in her presence. And I will receive Exhibit 3. Permission to publish is granted.
Yeah.
Your Honor, and actually for this point, I would ask that the court order the defendant to remove his mask.
Mr. Brooks, your order to remove your mask.
No, I'm not gonna do that.
Mr. Brooks, we talked about this at a prior hearing. For purposes of identification, your order to unmask. Thank you, sir.
So now I'll re-ask that question. Ms. Runkle, do you see Darrell, the person you're talking about in the video, either in the courtroom or on a monitor in the courtroom?
Yes.
Can you tell us where?
In orange?
On the monitor in front of you?
Yeah.
I'd ask the record to reflect that the witness has identified the defendant.
The record will so reflect. Thank you, Mr. Brooks. You can remask. Mr. Brooks, are you trying to ask her whether at the moment in time she first saw the SUV, did she know who was driving? That would be a relevant question.
Did you know who was driving the SUV that you saw when you saw it?
Not in court, but when you first saw it on that date.
Yes, because I don't see why Erica would be talking to anybody else and getting yelled at by somebody else.
But did you know at that moment who was driving the car?
Yes.
We have a lot of new technology in this courtroom, and it's great when it works. But it's a lot to get used to.
Excuse me, Your Honor, if I may ask you, are we still on the record right now, or we are? Okay.
We are. We're just taking a stretch break, but we're still on the record why they.
Okay. I was gonna say something to the bailiff, and I didn't want to be disrespectful by.
Do you want me to mute you for a second so you can?
Oh no, it's fine. It's fine. When will I be allowed to come back into the court so I can see everything?
You have earned your right to come back, sir. I mean, I can bring you back if you want to finish your questioning here.
I do.
All right, we'll take a short break for you to do that. All right, I'll have to excuse the jury for a moment. We'll be in recess.
Thank you. I think there may have been some misunderstanding on the nature of this statement in question. This witness provided a statement to a police detective who then wrote a police report summarizing the statement. So the proper method at this point for the defendant would be to confront her by orally quoting from that, asking if she said or didn't say these things. To show her this statement we're not refreshing her recollection. She didn't write this.
Ah, I see. So I didn't know that, but that certainly makes a lot of sense. Mr. Brooks, did you hear what Attorney Wichel just said about the procedure?
Is it a way to verify that that is in fact procedure? Just to be clear for the record. Can we verify it?
I had referenced earlier that I thought you were trying, we might be showing her the statement to help refresh her recollection, but I don't have any of the statements in front of me, and I wasn't aware that it's the police report that may be referenced as written by someone other than this witness. She wrote a statement apparently, but the police report is a summary of her statement. So
how it that kind of makes it problematic though. You could probably see what I'm getting at, Your Honor, by if it's a summary of what she said.
Do you have the statement do you have a written statement of hers?
Yes, I'm trying to get back to it. You know, I got a lot of stuff coming over here.
I know.
Once he finds the statement, I suggest that Mr. Brooks read directly from the statement the portions that he's asking the witness about and ask her if she did or didn't say those things he's reading.
Does the state have it available to put on the monitor if he's having difficulty finding his copy?
Sure.
Let's do that, please.
What was that? I missed that last part, I'm sorry.
It'll be on the monitor in front of you. Oh, we can, yeah, there you go. I'd like to bring the jury out, so let me know when you're ready.
Okay, I'm ready.
All right, let's have the jury brought back in. Mr. Brooks, you're doing a good job at coming up with questions and following the process, and I appreciate you asking to come back over here.
Hi.
Mr. Brooks, I want to commend you for a couple of things. Number one, asking to come back into the courtroom. I really appreciate that. I appreciate you being here. I think it runs much smoother when you are here, assuming you follow all the rules, which you have done a very good job at this afternoon. I also want to commend you on cooperating with the process even before you were brought over here. You were respectful. But you also made appropriate objections. You asked questions on cross-examination. Despite not wanting to unmask at first, you did do that, and I appreciate that. You asked some cogent, relevant questions, some of which went directly to the credibility of the witness. I would add, you might not always artfully ask the questions, but I think you're making some solid points. I would encourage you to keep prepping, to have questions written out based on the materials that you have. I really appreciate that you came back over and that you've been following the rules. I also want to encourage you, sir, to, if you choose, to wear your suit or other street clothes. It is your choice. I will let you make that choice. But I encourage you to consider that. Is there anything the state wants to address right now or any record you want to make?
No, Your Honor, thank you.
Mr. Brooks, anything you want to address right now or any record you want to make?
No, just thank you for giving me a chance to come back in, and I appreciate what you said.
It works well when you're here, sir. I hope we
Just
continue
say
this.
something very, very quick. I was waiting for my COVID results to come back before I feel comfortable getting back dressed up. So I kind of just prefer to just stay in the orange right now.
All right, that's your choice.
They said I should be having the results hopefully by the time I get back. I might know some. If not, I'll know some tomorrow morning. So that would be a big influence on
Okay, fair enough. The other thing is I had not been utilizing an all rise. Sometimes you stand, sometimes you don't. It is something I'd like to go back to, especially as it relates to the jurors. It's out of respect for them. So I will be doing an all rise for when the jurors enter and exit. And just given some of our logistics, I am not looking for an all rise for when I enter at all, so my bailiffs are aware of that. But that's it for today. Good night, everyone. We'll see everyone at 8:30 tomorrow morning. Calling State versus Brooks, 21 CF 1848. I have the state appearing by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and I have the defendant Darrell Brooks appearing in person. I have the jurors coming in a little bit later today, so I'm not, but they usually come early, so I'm not sure if they're here. But I did want to make sure and ask if there's anything the parties wished me to address this morning. I don't believe there's been any new filings. I haven't seen any, but I did want to ask.
Your Honor, from the state, we would just like to make a record with regard to the concern Mr. Brooks had yesterday about the juror that he believed he recognized from his initial appearance that may have made some type of hand gesture to him. I did not, unfortunately, write down the juror number. I know what the juror looks like, but I couldn't associate it on my chart. Do you recall the juror number?
I'd be guessing. I think I know what it is, but
Okay.
I don't want to be
Sure.
incorrect on that. But we can have the civilian bailiff provide us with that information.
I don't know if we want to do have that juror come out just to confirm. I know that the juror told the civilian bailiff who informed the court. Our concern is we certainly don't want Mr. Brooks to keep raising issues with regard to specific jurors, and we start using those alternates up. So I guess I'd prefer it to be on the record that that juror was not at the initial appearance. I know that the three of us were at the initial appearance. There was an older woman who did, I ended up talking to her during the proceeding. She was not the juror that was described yesterday or that I saw yesterday with the clothes that Mr. Brooks indicated she was wearing. So I just really would like that to be put on the record that that juror, in fact, was not at the initial appearance, and have her come in, provide her name, and do that. Or the juror number, not her name, her juror.
So my understanding is that following what Mr. Brooks described happening at the initial appearance, there was a woman that one of the deputies spoke with and warned her. It's my understanding that woman may have been in the gallery on Monday and was warned about behavior then. I have issued an order. She is not allowed back in these proceedings because of that. I believe we know her identity, and I can tell you with certainty it is not our juror. So, and if there's anything else, any other requests, I don't think it's necessary to bring that juror out, given that record. But I will certainly do that if the state feels, or Mr. Brooks, that that's important for their understanding or confirmation at this point.
Yeah, and I think what would be important is to note if her pool number is the first 41. Mr. Brooks actually was in court on day one of jury selection, I know for a fact. I'm in looking at my notes, it's unclear to me if he was present at any time in day 2 of jury selection. I know he was in day 1. So his claim that he was unable to see the juror at the time, obviously if it's a juror from day 1, he was able to see her because he was in court with her. So that would also be something, I guess if we could establish that she was part of the first 41, then I think the record is clear that the defendant was in court when the first 41 were brought out, and therefore he could have objected at that time.
I will get confirmation of the number, and we'll go from there. Well, any requests as it relates to that, Mr. Brooks?
Before I get to that whole issue, Your Honor, if I may, I would like to state for the record, and would like the record to reflect that I personally don't identify by that name. My name is Darrell Brooks Jr. I'm here as a third-party intervener in that matter, appearing as an authorized representative for my client. I accept for value, in return for value, all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
Your statements are noted for the record, sir. All right, as to the issue of the juror?
As far as the issue of the juror, I was maybe briefly present when the first wave of jurors were brought in. I didn't recall really being in here long enough to really get a look at the jurors coming in because I was removed at that time. Actually, either they were coming in or shortly after they were brought in, I was removed. I definitely was not present for the second and third wave. I was in the other courtroom, so it would be, I can't see the jurors from the other courtroom on the monitor, so it wouldn't possibly be that I would have seen the juror that I was referring to yesterday.
Understanding that that may very well be true, my recollection is you were removed pretty quickly due to an interruption early on. I don't have my notes in front of me as to when you were brought in or not, but I am advising you that I was able to confirm with others, including law enforcement, that the juror that you suspected was the woman who made an inappropriate gesture toward you at the initial appearance. They are not the same individuals. I've been able to confirm that. I know the identity of the woman who did what you said, and it is not this juror.
Is there any way that I can be sure of that?
Do you want to have juror, I think it might be 41, I don't want to guess, but I can bring that juror out when the jurors get here and we can have her under oath testify that she was not at your initial appearance or any of the proceedings in this case. I'm able to do that.
That would be helpful, Your Honor.
All right. Can we check to see where they're at and if they're here? And if so, to have that juror brought out.
Your Honor, I'm not interrupting, am I?
Give me 1 second. The juror will be out momentarily. Go ahead, Mr. Brooks.
I would like to state for the record, the prosecution seems to be saying this with firsthand knowledge.
You referring to the issue we're talking about right now?
Correct, Your Honor.
Is there a question with that, or I'm not understanding why you're raising that at this moment?
Well, I'm raising it because the prosecution said that, and they stated that they knew for a fact that this juror is not the juror that I'm speaking of.
I said that.
Well, the prosecution said it too, Your Honor.
I provided the information, said I've been able to confirm the identity of the person who made an inappropriate gesture to you at your initial appearance. And then based upon the informal questioning of the juror that you suspected was that, determined confirmed that she was not that individual, and then subsequent to confirming that informal information, I was able to do some additional questioning of law enforcement and others to determine the identity of that other person and confirm, in fact, that what you said happened, but it's not this juror. But we're going to bring that juror out just so you can, or I will, question her about that. So there's a very clear record that your concern and whether one of the jurors on this panel was at your initial appearance and made an inappropriate gesture can be put to bed once and for all, so that you're satisfied they are two different people, okay?
Thank you, Your Honor.
All right. Do you want to take over? No, yes, Just can sit in the jury box. She's a juror. She may be put under oath and questioned, but she's a juror, and so no one can film her or take her photograph. Go ahead. She can just sit in one of the spots in the jury box. All right. Good morning. You can have a seat. I just want to put on the record, this is juror number 41, and you are not in trouble. We just have had an issue come up, and we wanted to make sure we all had accurate information. At any point in time, did you attend any of the proceedings in this matter regarding Mr. Brooks? No. Were you ever at the initial appearance for Mr. Brooks? No. All right. State have any follow-up based on that?
No, Your Honor.
Mr. Brooks, any follow-up based on what I've asked this witness, or what I've asked this juror, sorry?
No.
All right, thank you. Thank you so much. And I'm gonna wait till she's back out of the courtroom, because there's a hallway behind me, and then ask a follow-up. Are they gone? Mr. Brooks, we brought out juror number 41. Was that the same juror that you initially suspected was someone who was at your initial appearance?
Yes, Your Honor.
All right. And again, she denied. She said she told us she wasn't there, and I trust that satisfies your inquiry into this issue.
I'm still a little leery, but
Okay.
I say that. I'm not interrupting, am I?
Go ahead.
I say that because I don't forget faces. I don't.
All right, I understand what you're saying, but the record is made clear, and I'll make a finding that juror number 41 was not at your initial appearance and is not the person who made an inappropriate gesture to you either at or following that hearing. All right, then any other issues from the state?
Yes, Judge, just briefly, a few. From yesterday's testimony, we'd like to move into evidence Exhibit 1, which was the map, Exhibit 3, which was the video played during Corey Runkle's testimony, and Exhibit 5, which is the photograph of Erica Patterson. They were all testified to yesterday.
Any objection, Mr. Brooks?
Yes, Your Honor. I guess it would be to the terms of relevancy. There's been no testimony from Ms. Patterson, so I'm just curious to know the relevancy of that being made evidence at this point in time, because from what was said yesterday was that she would be testifying at some point. Would it not be better to have that admitted then if she decides to testify instead of right now when we're not even sure if she is going to testify?
Your objections are noted for the record. There was a proper foundation laid regarding each one of these exhibits. They also are relevant to the issues within this trial, and I'll admit exhibits 1, 3, and 5, and also advise the jury when they come back into court this morning.
Your Honor, I'm not interrupting, am I?
Hold on, I'm not to you yet. If there are any issues, any other issues from the state.
Yes, Your Honor, I would just like the record to indicate that I understand we did not follow up with this after the lunch break on the record, but it was my understanding that Mr. Brooks did receive the medical attention that he was seeking over the lunch hour. So I just wanted that on the record. And then finally, Your Honor, just a reminder to Mr. Brooks as to the other acts evidence. In line with his questioning of Corey Runkle yesterday, Erica Patterson will be testifying here this morning. The court issued a ruling as to the other acts evidence. The state strictly abided by that. Mr. Brooks came very close several times to opening the door to that testimony. We treaded very lightly on purpose. Before we start another round of challenges potentially during Ms. Patterson's testimony, we just wanted to make a record of that so that Mr. Brooks knows if he opens the door to that other act's testimony, it will come in.
All right, I appreciate the state raising that as well. Mr. Brooks, on the issue of medical attention, did you see the jail nurse or other medical personnel during the lunch hour yesterday?
Yes, I did. I received a cleaning of my cut and a bandage.
All right, thank you.
Oh, I'm sorry. I was getting to the other parts of the injuries. They
Go ahead.
viewed the bruises that I have on my arm and legs as well. I don't know what's going to happen behind that, but I was looked at.
All right, thank you. Does not appear to me that any of these injuries are interfering in any way with your ability to be here today and assist in your own defense. So that's good.
Yeah, I'm just a little tender, just a little sore. So.
All right, Mr. Brooks, do you understand what the state is referencing as it relates to the other act's evidence?
I do not understand.
Do you recall being in court at the end of August when the court addressed a number of motions, including a motion brought by the state to admit other acts?
And with all respect, Your Honor, this whole process is very, very new to me. So I'm trying to, I guess, stay within bounds of the questions that I'm allowed to ask. If I color outside the line, so to speak, it is not intentionally, because I'm basically learning as I go.
So I'm going to have my clerk print out the motion for other acts that was filed by the state, along with the response that was filed by your attorneys at that time, and further advise you the court did not grant the state's request to admit other acts as it relates to your conduct with Erica Patterson prior to November 21 of 2021. And your questions yesterday of Ms. Runkle could have opened the door to the court revisiting that issue. That's why the court stopped. It was interesting. Ms. Runkle clearly was advised not to talk about other acts. The state followed the requirement that they advise their witnesses about the court's order as it relates to other acts. And I believe I kind of paused twice and said, "Are you sure you want to answer that?" I referenced generally some prior rulings so as not to alert the jury to anything more than that. And then at one point, Attorney Wichow also came over, muted your microphone. I don't know what was said, but my understanding is he basically kind of gave you the same caution. There's a ruling, something to that effect. And I know you didn't proceed with the questions that you had originally attempted to ask this witness. So it's very clear what we're talking about. Again, I'm going to give you these filings so that you understand what I prohibited in this trial. And the record should reflect those filings are being provided. Madam Clerk, do you happen to have the document numbers for those? Sorry, I should.
170.
Document 170.
And 161.
161. So documents 170 and 161 were provided to Mr. Brooks. So the only other thing I'll say on that, sir, is if you ask questions, I'm not going, that would open up the door potentially, or at least ask questions that call for answers that might fall within that order that I issued. You do that at your own peril, and you may open the door to the state bringing in other witnesses and other testimony about those issues. So I want you to be advised of that. You are correct that when the state made the request, I prohibited the state from introducing that evidence. So you're not incorrect when you say I didn't, when you kind of referenced about that was there's a difference between me prohibiting you and prohibiting the state. But from my perspective, the order that I issued was to your benefit. And so you can ask those questions. You're not prohibited, but then you potentially open the door to that information becoming admissible in this case. So I want you to be advised of that.
May I quick, Your Honor?
Go ahead.
I would just like to say that I accept for value in return for value these filings. I do believe that I have a little bit more clarity, if that helps.
Thank you for putting that on the record. Do you have any other issues you want me to address?
Just very, very quick. I still don't understand the nature and cause of the charges against me, Your Honor, and I still would motion for, or tennis motion for the jurisdiction to be proven, the subject matter jurisdiction. And also a motion for finding of fact.
Your requests are all noted for the record, and for the reasons previously stated on this record, I'm not going to answer those requests any further. They've already been denied by the court. I'd point you to the case of, can I have my post-it note back? The Beneby decision at 654 F 3rd 753. All right, anything else, sir?
I'm not interrupting, am I?
No, I'm asking you a question.
Just for the record, Your Honor, I would like the record to reflect, is that a judicial determination that you are making?
Your Honor, Mr. Brooks, the record speaks for itself. I've made my decision. We're moving on. All right. With that, then, State have a witness available to be called.
We do. Would you also just make a record, Your Honor, this morning that Mr. Brooks does appear again in his orange jail uniform, and that he was offered the ability to wear street clothes and declined that offer? Also, he does have appears to have all of his discovery materials at the table with him.
Yes, thank you. I should make a record of that as well. I didn't state at the outset Mr. Brooks is here in person and in custody. He once again has come to the courtroom in jail attire. I presume, Mr. Brooks, but please confirm for me, you were offered the opportunity to change into street clothes?
As I stated on the record yesterday, I'm waiting for the results of the COVID test that I took. So until I get those results back, I would prefer to not wear street clothes at this time.
All right. Can you confirm for me, though, that you were provided an opportunity to change into them if you so chose?
And not to my knowledge.
Sir, I'm providing you with that opportunity right now. If you would like to change into your street clothes, into the suit and tie that you had previously, or any other street clothes, I would give you that opportunity. Did you hear me advise you of that just now?
I might consider it. Maybe I may have more information from the medical staff once we take a break, or maybe I'm anticipating. Well, actually, I anticipated that I would know before we even started court. So that.
Do you want me to have the bailiffs ask the CO if there's any new information that can be relayed to you before we bring the jury out?
That would be helpful, Your Honor.
Do you have any objection? I could email the jail administrator if you want, or I can just simply have the bailiffs do that.
Whichever works best for Your Honor.
All right, let's see. She's not going to give me information in an email, that much I know, but I could at least find out if there's new information. If there's new information, then it's going to have to be given to you directly. That may require you to be taken into the holding cell to be given that information, okay?
I'm okay with that.
Okay. Let me just continue that. Again, right now he's in the jail attire. We're going to give him an opportunity to see if there's any update regarding the testing that was done earlier this week. And until we at least get word whether there is new information or not, we'll not bring the jury out. I will make a record that Mr. Brooks does have the 3 boxes that have been referenced previously. I see the objection sign. I see the selected statutes that the court provided to him previously, and I see he has a number of papers in front of him. So he looks as if he's prepared to participate meaningfully today.
May I say something real quick for the record, Your Honor?
Sure.
I did bring these boxes up. I have not had the time to go through everything in there. As you can see, it's a lot. And that's putting it minimal. A lot. So I have not had the time to go through everything that's in there. I'm winging it, Your Honor.
Deputy Wittig, any new information? Yeah. All right. Well, can you provide that? Well, let me just see. We'll just do it. All right. All right. The information that I have on whether there's new information is they don't have the results, but medical will be called again to check on that to see if anything new. Any new information is available, but as of right now, there's not. I also was advised that you were offered 3 times to have street closed by Officer Gabor. Just want to make a record of that. All right, then, Mr. Brooks, we don't have apparently new information. I intend to just continue then, okay?
Really quick. To the decision of Your Honor for me to be removed from the proceedings over the last few days, that was used from the Illinois versus Allen, right?
Correct. I also had cited to a case that I believe is on point, although not binding on this court. I am persuaded by the reasoning in United States versus Jennings, found at 855 F Sup 1427, which is from 1994, from Pennsylvania. And as well as, sorry, just that one. That was affirmed by the Third Circuit in United States v. Jennings, 61 F 3rd 867, Third Circuit, 1995. So the first decision I referenced was a federal district court decision, and then the Third Circuit decision. Let me know if you need those citations again.
Does any one of those mention the being present through audio and visual?
Yes, audio. In other words, the defendant in that case, who also was a pro se defendant, was removed from the courtroom after he said he would continue disruptive conduct in the presence of prospective jurors, but he was able to continue to listen to proceedings through loudspeakers and transmit messages to the court, was barred, and what the court held is he was barred from the proceedings by his own conduct, not by the court, and the conviction in that case was affirmed. Do you want that citation again?
No, I'm not interrupting, am I?
No, go ahead.
I do represent myself pro per. I would like that stated for the record. Like the record to reflect that, not pro se.
The record will so reflect your choice of term to describe your appearance today.
I've briefly read Illinois versus Allen. It didn't say it didn't give any reference at all to him being present by audio or visual in that case whatsoever. It just strictly talks about the reasons that he was removed and the options that the judge had in that. One of them being that he could be bound and gagged. One of them being that he can be held in contempt and removed from the courtroom while the trial would continue, but it did not say anything about being present visually or audio or by audio.
Well, I appreciate you reading the case, sir, and providing that information. I'm well aware of what the case says. And as that case says, the Supreme Court talked about there would be no one formula for maintaining the appropriate courtroom atmosphere, and no one formula will be best in all situations. But the Supreme Court said this: we think there are at least 3 constitutionally permissible ways for a trial judge to handle an obstreperous defendant like Allen, going through the 3 things that you identify. And my findings here are that there's a 4th way, and that's through the wonders of technology that weren't available in 1970 when that decision was authored. So I appreciate the notation on the record. You are here today, and I hope you stay here today. That's certainly my preference. You've demonstrated you're able to prepare, you're able to ask questions, you're able to articulate in a clear, coherent, cogent, and responsive way. And I'd like to bring the jury out, and that's what we're going to do next.
I'm interrupting real quick. I just want to say something very quick to that.
Very quick, sir.
I don't see that 4th way, Your Honor. Also, when they
Mr.
talk,
Brooks, my decision stands from previous. If you believe there's any error that I made, that is for you to address if there is a conviction and on appeal. But my decision stands. And the record speaks for itself.
May I put on record that I intend to appeal that judicial decision, Your Honor?
Understood. You may appeal as you deem appropriate.
Thank you.
All right, thank you. Let's bring the jury out. I will ask everyone stand for the jury out of respect for them.
Your Honor, I'd ask that the court have Mr. Brooks temporarily remove his mask.
Mr. Brooks, you're advised
To remove your mask, please. Thank you.
Ms. Patterson, do you see Darrell Brooks in the courtroom today?
Yes, I do.
Can you tell us where he's sitting and what he's wearing?
On the left side, and he's wearing an orange shirt and a mask.
I'd ask the record reflect that the witness has identified the defendant.
The record will reflect that this witness has identified the defendant.
To show what happened in front of the White Rock School on November 21st of 2021?
Yes.
I move Exhibit 4 into evidence and request permission to publish.
Any objection?
Yes, we haven't even played the video. How do we know what's even in the video at this point? Can we see the video before it is admitted into evidence?
Your objection is noted. The foundation has been laid. Exhibit 4 is received.
And permission to publish is granted.
About the
The incident on the 21st, I did. The next day I let him know about the incident on the 20th is what happened.
Okay.
Yes.
Thank you.
To make it better. Sorry.
Good. That's all I have, Judge. Thank you.
Thank you. You may step
Thank
down.
you, Your Honor.
All right, and any reason to keep her under subpoena from the state?
No.
From the defense?
Yes.
Did you have a subpoena for her?
To my understanding, I was supposed to.
All right, I'll take that up in a little bit. For now, I'd ask that she be maintained under the state subpoena until I can clarify that issue. All right, state have the next witness available.
Yes, we do.
Mr. Brooks, please. Before the next witness comes in, if my ladies and gentlemen of the jury want to take a quick moment to stand.
So would it be fair to say, though, that the information wasn't completely forthright?
Yes.
To the best of your knowledge, would it be fair to say that there was in fact only one incident?
No.
And would you be basing that, to the best of your knowledge, would you be basing that answer, the last answer, on hearsay?
No.
So you would be basing your answer on eyewitness account?
I'll check that. Relevance.
Grounds.
I'm going to sustain the objection. Next question, or you can rephrase it.
Would it be fair I don't know how I can rephrase that without asking it the same way, Your Honor. Just give me a second, if I may. At any time during your report or time spent with Ms. Patterson, did she state where she may have been on November 20th of 2021?
Yes.
Do you recall what that was? What she said?
I recall what she said, yes.
To the best of your knowledge, do you believe that she was being truthful?
Yes.
I'm just going to advise the jury that ultimately it's the jury's determination of credibility that matters. And you heard me read an instruction yesterday. That's obviously the instruction you'll follow ultimately in the jury room. Receive that.
I was made aware of my I didn't look at it yet, so.
Do you have it with you?
It is. It's in my paperwork somewhere.
All right, I need you to locate it and open it up, please.
May I ask the reason why that would be?
Mr. Brooks, you raised this issue yourself, and I'd like to know the result.
I would too, but I was kind of in the middle of preparing for my defense, so
Mr. Brooks, find the piece of paper and open it up and read it, please.
Your Honor, I don't consent to being talked to in that fashion.
Your lack of consent is noted for the record. Please find the piece of paper, open it up, and please read it.
I will not consent to that, Your Honor. Or do I agree to that, Your Honor? I do not.
Mr. Brooks, then I'm going to advise the Sheriff's Department to find the piece of paper and hand it to me so that I can read it. So that those are your two options.
What would be the basis for that, Your Honor?
Mr. Brooks, this is an issue that you raised, and I need to bring it to finality and know what the test result is.
Okay, with all due respect, it was a motion that I raised.
All right, I'm going to clear the courtroom. We're going to go off the record, and we're going to find that piece of paper, and I'm going to address it when that's done. Take a recess so that the test result could be obtained, and if necessary, by reasonable force. It's my understanding there was some type of situation or altercation between Mr. Brooks and the deputies. Ultimately, though, I think he was taken into the bullpen. He was brought back out, but it was very clear to me that he was upset. I think understandably so, but I needed to make a record of what was being done, including that I have obtained the test result. So there's an accurate record in this case related to the motion that was raised previously by Mr. Brooks. I want Mr. Brooks to know that I am not removing him from when the jurors are brought back in. It was just simply because he was upset. He was very loud when I walked into the courtroom before going on back on the record. He was yelling about his constitutional rights being violated. I advised him that if there was any type of use of force that he wanted to complain about, he could certainly do that through the proper channels with the Sheriff's Department, but just given his state of agitation and my need to make a record, I had him taken to the other courtroom. He is currently muted. I do not intend to go forward with additional testimony. Ultimately, I'm going to take an early lunch break because of this, but I will make a record of the following. I have the result. I am going to scan it, have my clerk scan it. It will be filed as confidential, though. It won't be available to the public, but it's there for appellate purposes, but I can confirm that the test result for COVID-19 was negative. And again, I required the Sheriff's Department to provide that result to me, and it was, and it will remain under seal. I realize I'm disclosing that result, but I feel obligated to do that given the motion that was raised 2 days ago by Mr. Brooks. Again, I intend to take an early lunch, so that will hopefully give Mr. Brooks an opportunity, if he so chooses, to review the result himself. It was put in front of him. I did see that he either shoved it or tossed it or just dismissed it. It looked like it went on the floor when it was put in front of him, but we'll certainly have the deputies give that to him again. During the recess for lunch, Mr. Brooks will also be given the opportunity to change into street clothes if he so chooses. But when we come back, he will be in this courtroom. I agree. Mr. Brooks was making a couple of statements about how he was abiding by the rules and being respectful, things of that nature. I agree. He's done an excellent job while in court here this morning. He's been respectful of the rules. He made some early on. I let him, make his objections or lack of consent. He did that respectfully. When I said I was moving on, he generally was able to do that. We were able to get through 2 witnesses. He was able to follow along, ask cogent, clear, responsive, and articulate objections. He was able to elicit information from the witnesses regarding either their memory, their credibility, and other things. Generally speaking, he's been able to competently represent himself and provide, again, solid cross-examination this morning. So I'm going to give him an opportunity to hopefully settle back in and to come back here when we return from lunch. So with that, we are in recess. Probably come back at 1 o'clock, since it's only 11:30, and we'll take the full 90 minutes for lunch today. All right, thank you, everyone. Thank you. Brooks, anything you want to address at this point? It's hard for me to see his head. He's bent over, but I thought I saw him shaking his head. No, but I'll ask one more time. Mr. Brooks, anything you want me to address before the jurors are brought out to continue with testimony from witnesses?
Just a little emotional right now.
All right. Let's bring the jury out. We'll continue. I presume the state has a witness available.
We do.
All right. Thank you. Mr. Brooks, the jury is headed out, but why don't you hold off on that, and at the next appropriate time when they're not on their way in, I can address whatever it is. Or if you want to pass me a note, you can do that as well.
I asked her what was wrong, what was hurting, if there's anything more serious with her as she was being held up. And she said, "Officer, I saw what happened. I saw who did this." And I said, "What can you tell me?" And she said, "A red SUV sped through the parade and did this." She didn't say anything more than that. I said, "Okay." I was like, "Stay with your family, stay with your parents. Somebody will be by with an ambulance to get you shortly."
These three injured individuals you spoke to, would you describe them all as being about teenage years?
Objection.
Overruled, he may answer.
This is the grounds, Your Honor.
Overruled, he may answer.
So is he gonna answer to the question, to
Yes.
the prosecution table, or to the jury? I'm not sure. He's looking at them answering the questions, but they're not answering the question, asking the questions.
You may answer the question, sir.
The three individuals that I met with initially had band uniforms on, and it was my understanding that the band from that vicinity right then and there was a high school band, so I would place them all at teenage age range.
Okay, thank you. Were you aware that at some point a person was taken into custody in the 500 block of Elizabeth Street that was related to this incident, sir?
Objection, irrelevant.
I'm sorry.
No, go ahead. You have your next witness.
Yes, I'd also like to move Exhibit 1C into the record, please.
Exhibit 1C is received.
Thank you.
I object to that, Your Honor.
Your objection is noted.
Can I state the grounds, if I may?
You may.
There's a point in the video that was shown, like during the interview part between the officer and the 3 individuals were,
That's not the exhibit we're talking about.
well,
We're talking about 1C, which is the annotations to the map that were made that are captured by the annotation system that the state just moved in and the court received.
okay. I didn't understand what was being referred to. I was gonna bring this up, but I wanted to wait.
Sir, let's take it up outside the presence of the jury later on. You'll have to remind me later. I've already received the video, which is exhibit number 6.
That video has some language in it that you made an order on. So I just want to put that on the record. Something that you ruled on.
Sir, we'll take it up outside the presence of the jury. All right? I need to keep going on. Next witness, please.
State will call Kyle Edwards.
All right, Mr. Edwards.